Welcome to the lesson on Tolent clauses after Yuanda, allocation of adjudication costs in construction disputes. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. The allocation of adjudication costs, who pays the adjudicator's fees and who meets the party's legal/consultancy expenses, has produced a persistent body of litigation and commentary. Two competing tensions run through the authorities. On the one hand, parties are generally free to agree contractual cost-shifting arrangements, the so-called Tolent clauses. On the other, the Housing Grants, Construction and Regeneration Act 1996, HGCRA, and the statutory scheme for construction contracts protect the right to adjudicate at any time and guard against contractual terms that would effectively sterilize that statutory right. The courts have tried to reconcile those principles in a line of decisions that remain important for practitioners. The case of Yuanda versus WW Gear Construction Limited, 2010, became a turning point in this regard. The contract in Yuanda contained a Tolent-style clause, which required the referring party, and only the referring party, to pay both sides' adjudication costs and the adjudicator's fees. The court held that this asymmetrical clause conflicted with Section 108 of the HGCRA 1996, effectively discouraging the right to adjudicate, and therefore displaced the parties clause with Part 1 of the scheme. The judge also held that a very low contractual interest rate, 0.5% over base, did not amount to a substantial remedy and was inappropriate compared to statutory rates. Yuanda therefore stands for the proposition that where a clause would meaningfully fetter the statutory entitlement to adjudicate, the court will treat it as non-compliant and impose the scheme instead. The legacy of Bridgeway and Tolent and the present position. Earlier cases such as Bridgeway v. Tolent had upheld negotiated Tolent clauses where they were reciprocal and freely agreed. Yuanda did not overrule the possibility of fair, reciprocal cost clauses per se, rather it struck down a non-reciprocal and punitive variant that would deter one party's access to adjudication. Commentary since Yuanda notes that Tolent clauses have persisted in forms and that care must be taken when drafting cost allocation provisions to ensure they do not frustrate the statutory scheme. From the authorities and commentary, several practical rules emerge. First, reciprocity matters. A cost-shifting clause that applies equally to both parties and was freely negotiated is more likely to be upheld than a clause that burdens only the referring party. Bridgeway and later commentary explain this distinction. Conversely, non-reciprocal or punitive Tolent clauses that chill the statutory right to adjudicate are vulnerable to displacement by the scheme, as in Yuanda. Secondly, there is the possibility of scheme substitution. Where a contractual adjudication regime is incompatible with Section 108, the court may replace it with a statutory scheme Part 1, thereby neutralizing unfair cost provisions. Yuanda exemplifies this approach. Fees liability may be ordered against the losing party, but recovery is not guaranteed. Adjudicators typically allocate their own fees between the parties. Courts will enforce such allocations where the adjudicator had jurisdiction and proceeded fairly. But if the award is successfully challenged, for example jurisdictionally, or if the adjudicator's fees determination falls outside the adjudicated dispute, enforcement against the other party may be refused. Practitioners should therefore not assume fee orders are unassailable. Thirdly, we must consider commercial reality and access to adjudication. Courts are aware that heavy or one-sided cost clauses can chill access to the quick, interim remedy Parliament intended. They will therefore scrutinize any cost allocation that would discourage the use of adjudication. This policy posture has guided decisions since Yuanda and continues to shape TCC practice. Practical implications for contracts and practitioners. Draft reciprocal cost provisions if parties genuinely wish to shift adjudication costs. Ensure the clause is transparent, negotiated, and not punitive. Drafting asymmetry invites a Yuanda challenge. Expect the scheme to fill gaps or replace non-compliant provisions. Do not rely on creative Tolent drafting to immunize cost shifting. Be cautious about relying on adjudicator fee awards alone. If the underlying award is vulnerable to jurisdictional challenge, recovery of those fees may become complicated. And lastly, consider litigation funding or insurance for high-value or high-risk adjudications where cost exposure is significant. Commentary notes increasing interest in litigation funding for construction disputes. We hope this lesson was helpful to you. Thank you for your interest in this topic, and we are looking forward to seeing you again soon.